Good morning, everyone. My name is Maggie Jo Buchanan, and I am the Senior Director and Senior Legal Fellow for the Women's Initiative at the Center for American Progress. Thank you so much for joining us this morning. Since Roe was overturned, the world we live in has far too often been one of chaos, confusion, and unnecessary suffering. Basic freedoms have been denied. Women experiencing pregnancy loss have reported being forced to suffer in pain, to get sicker, before their doctors feel they are legally able to help them. Even before Dobbs, medication abortion made up more than half of care in America. A two-step regimen that was first approved in the US for early abortion care over 20 years ago, the method has proven to be outstandingly safe as well as effective. And now, as states have banned abortion, forcing clinics to close and patients to travel for care, driving up wait times for appointments where they remain open, the importance of this method, which can be safely sent through the mail to be taken in the comfort and privacy of one's own home, have only grown. Recognizing these two facts, medication abortion's safety, as well as its importance in ensuring access to care, are critical to grounding today's conversation. An Alliance for Hippocratic Medicine versus the FDA, the plaintiffs, among their many claims, deny this safety record and allege that one of the two medications, mifepristone, should never have been approved. Let's be clear. This case is about ideology and a willingness to go to extreme lengths, politicizing medicine and disrupting legal norms in order to assert that ideology on every person in our country, no matter what ramifications may result. Today, you'll hear a lot more on this topic from our panel of experts. But first, I am very pleased to introduce Patrick Gaspard and Representative Lizzie Fletcher from Texas, who will begin today's event. Patrick is the President and CEO of the Center for American Progress, as well as the CEO of the Center for American Progress Action Fund. A key figure in President Obama's administration, Patrick also most recently served as a president of the Open Society Foundations before joining us here at CAP. Needless to say, we're very lucky to have him. Congresswoman Lizzie Fletcher represents Texas's 7th congressional district in the greater Houston area. Before her election to Congress, Representative Fletcher represented Houstonians in the courtroom as a lawyer on a wide range of matters. Now in Congress, in addition to serving on the Energy and Commerce Committee, the Congresswoman is a leader on key caucuses, including her role as whip of the pro-choice caucus. In addition, she is one of 12 members of Congress appointed to serve on the Regional Leadership Council, where she works with President Biden to ensure implementation of Democrats' legislative accomplishments throughout the country. Again, thank you very much for joining today's conversation, and I'll turn it over to Patrick.
Thank you so very much, Maggie. I want to really thank Representative Fletcher, who's joining us as she manages to dip and glide in another really important hearing on Capitol Hill today. But I also want to extend that gratitude to all of our panelists and to all of you who are gathered with us in this really important discussion. Let's get right to it. Representative Fletcher, we're going to cover several topics today. And of course, we're going to spend some time on medication abortion. But if we could, I want to just pull back the lens a bit and start by just centering the people in your community who are being directly harmed by these dangerous and unjust laws and continued attacks on their health and well-being. I heard you say once that when you were a practicing lawyer, you learned quickly that you're not the expert on anything and that your clients are the experts and you had to learn to listen to them. Now that you represent 700,000 folks in Congress, and I know that you are somebody who's incredibly grounded in Texas, in Houston, help us understand what you're hearing now. You've been at this for a long time. When you were in high school, you were on the front lines of pushing back against violent demonstrators who were attacking women who were coming in for services in a clinic. Help us understand in this moment, as we're seeing all of these laws, all this reactionary politics from judges, even what you're hearing, what you're feeling from those women and their families, and what you believe they most need now from all of the rest of us.
Well, thank you so much, Patrick. I'm so glad to be with you this morning, and I'm so glad that CAP is focusing on these hugely important matters in today's discussion. And you're right. I mean, as you said, these are difficult days for Texas women. And we see that Texas really is the epicenter of efforts to take away our freedom to make our own decisions about our bodies, our families, and our futures, and our access to services and to information that enable us to do so. And as you said, I've been in this fight a long time, and I think we are in a new phase. And I think it's really important to understand where we are in this moment. I know we're going to talk a lot about the medication abortion decision, and I think that that's really important because it really fits into this dynamic that we have seen in Texas for decades of eliminating access to services, even if the rights are nominally available. If you can't access services, if you can't access healthcare, then you don't have it. And that's what we see in this particular legislation. It is in this particular litigation. It is also what we see in legislation, and we've seen it in Texas for decades. And so I think it's really important to understand that this is a comprehensive strategy. And for those of us who've heard for many years that Roe v. Wade and overturning Roe v. Wade was the goal and the end of the road, I think what we see and what should be apparent to everyone now is that that is not the case. And so I'm happy to talk a little bit about the medication abortion decision in particular, but I think it is really important to emphasize where we are in this moment. And certainly we are seeing it and witnessing it in Texas. And what we are in Texas is really a healthcare crisis and a
The representative appeared.
healthcare crisis. Yep. Can you hear me?
We can now. Yes.
Okay. Oh, sorry.
No, don't, please. We caught all of what you were saying. You were saying that
Okay.
Texas is at the epicenter, that we're faced with a healthcare crisis in Texas now. I go so far as to extrapolate based on everything that you've said that it's a real democracy and rights crisis in Texas as well, and one that's national. And of course, you're right that the Dobbs decision, the Roe decision, was the tip of the ice, was that kind of a point of entry into a broader challenge we have. Let's turn to medication abortion. When we speak about medication abortion, we're also talking about the preservation of privacy as well as equitable access to abortion care due to reduced costs. Could you explain why medication abortion, as well as why it's critical, and help us all understand the implications of this case beyond abortion care, and not only in states that have already banned abortion, but in states that support access as well? I know there's a lot in there, but you're at the front lines of all of it.
Sure. And I hope I wasn't disconnected for too long, and I hope I'm not repeating myself now by saying that the issue of medication abortion really fits into this larger strategy, which is about eliminating access to services. And what we know about medication abortion is that it accounts for more than half of abortions performed in the United States today. We also know that this is a safe and effective method of abortion care. And we know that it's been more than 20 years since the FDA approved mifepristone, an abortion pill, which has been proven safe in use for decades. And that's what's at the heart of this case. And I know the panel will discuss in more detail later. The case before this district court in Amarillo, Texas, is really unprecedented because it's asking a judge to overrule the FDA's approval of mifepristone. And it's really asking it on ideological rather than scientific grounds. And this is something we've never seen before. And the case has far-reaching implications. And that's why so many people are deeply concerned that the judge could issue a ruling for the plaintiffs in this case that would take these abortion pills off pharmacy shelves across the country immediately, not just in Texas. And so this would immediately eliminate access to safe, effective abortion care that is the preferred method for many people for many reasons in all 50 states. So this is a case with nationwide implications for abortion care, but I think it's also really important to point out that the implications go far beyond abortion care, because what we're talking about here is really seeing decisions being made about the drug approval system by a court and trying to override an agency full of experts about the safety and efficacy of a drug. It's never happened before, has incredibly dangerous consequences. Determining the safety and efficacy of drugs should be left up to scientists and not political appointees, not judges, and not legislatures. And that's something we've seen consistently, that people want these decisions to be made by physicians and their patients. When it comes to healthcare, they want decisions about drug efficacy made by the FDA and not by lone courts in the state of Texas or any other state in the union.
Thank you for unpacking that with such clarity and force of conviction, Representative. So you say that these drugs are safe, they're tested. We have over 2 decades of their safe usage in this country. And of course, you are absolutely spot on to say that this is driven by ideology and that the American people want healthcare providers and scientists making these kinds of decisions. But the reality is that we do live in a world where these matters are governed by politics and public policy. You happen to sit on the influential Energy and Commerce Committee, which has jurisdiction over a variety of drug-related matters. Speak, if you would, about the importance of the independence of the FDA and what you and your colleagues, both Democrats and Republicans, are doing to assure that autonomy and that protection from ideological bias in the drugs that are available to us on the counter, over the counter.
Sure. Well, I think it is really important to understand the process matters. And you referenced in your opening that, I always look to others as the experts and on the process. And in no place is that more clear than when we're looking at the regulation and approval of specific drugs. The FDA's process to determine whether a drug is safe and effective is a complex, time-consuming, and extremely rigorous process. And that's why it's considered the gold standard drug approval process. But the process does have to be driven by science, not by ideology. And it's really important that the FDA maintain its independence. And look, you can see it's not hard to imagine where this case and where political interference with this process could go. What is stopping a group that, say, opposes vaccines from suing to revoke the approval of vaccines? So we really have to be careful and thoughtful about what this could do. And I think challenging the authority of the FDA to approve important life-saving medications that are critical to our society's health has a huge impact that we can't even imagine on everyone across the country. And so, when you asked what are we doing about it in Congress, I think we are seeing a real effort in all of our legislative bodies to intervene with science and replace it with ideology, and that's incredibly dangerous. As I said before, medical decisions should be made between doctors and their patients, not by politicians. The vast majority of Americans agree with this in the context of abortion care in particular, but also in all other contexts where people are seeking medical advice. And that is true of what we are wanting to see happen through the FDA process. And I think Congress has an important role to play in ensuring that principle. And although we are in the minority right now, Democrats are fighting back against politics getting in the way of science. My colleagues and I will continue to introduce and fight for common sense legislation that puts science and puts patients first. And it's also important for us to bring attention to some of the really harmful bills that are coming through the floor this Congress, like 2 anti-abortion bills that came before us in January, making sure that people know about these attacks on both our personal freedoms and our ability to make our own choices, and also on science. And I think we have to be very, very careful to guard against both.
Representative, you said in your introduction that this has really been a multi-pronged attack over many years. One of the things that I most admire about your leadership is that you're multi-pronged in how you take all of this on. In addition to the important work that you're doing in this moment to protect the access to medication abortion, you also have a bill that would protect the right to travel for families in need of reproductive health care, but not able to access that care in their own home state. Now, I think it's absolutely bizarre and says really quite a lot about the state of our country that such a bill even needs to be filed. But can you tell us about the bill, why it's important, where it stands now, and how you're going to manage to get the kind of support that it needs to get this into law?
Yes, thanks. And thanks for mentioning that. Last year, I introduced the Ensuring Women's Right to Reproductive Freedom Act to reaffirm the constitutional right to travel across state lines for medical care, including specifically for abortion care. And it passed the House of Representatives in the last Congress, but it failed to pass the Senate. So I have reintroduced it in this new Congress. And I agree with you. It says a lot that we need this bill. but I can tell you without a doubt that we do. In Texas, which is, of course, when you were asking earlier, so much of what I do is driven by what I'm seeing at home and hearing from my constituents. And in Texas, after Senate Bill 8, SB 8, which was about 9 months before the Dobbs decision, and increasingly after the Dobbs decision, which eliminated virtually all access to abortion in Texas, Texans began traveling out of state more and more to obtain abortion care. And in response to this exercise of their constitutional right to travel, lawmakers and others in Texas and across the country started threatening to take away that right too. We're seeing it in bills filed in our legislature again in this legislative session, and we're seeing it filed in other states. And I just want to reiterate, the bill is very simple and it reaffirms the right to travel. And the right to travel freely and voluntarily among the states is one of the chief privileges and immunities guaranteed to all citizens of the United States by the 14th Amendment, and is one of the fundamental rights guaranteed to all persons under the 14th Amendment's Equal Protection Clause. And Congress has the authority, certainly, some people have asked me if we do, we certainly have the authority, but really we have the obligation to protect people from these unconstitutional efforts to restrict or impede their travel or otherwise retaliate against them, people traveling across state lines to obtain a legal abortion, and to protect the healthcare providers and others who assist a person traveling to another state to obtain a legal abortion. And I just want to reiterate, this is not hypothetical. We didn't file this bill. I didn't put it out there because it was, theoretically possible. Members of our legislature in Texas are sending demand letters to employers that they eliminate this kind of coverage from their healthcare plans, that they not give employees time off to obtain abortion care. And we've seen just in the last couple of weeks in Texas, some of the terrifying lawsuits that are being filed against people seeking abortion care. So this is absolutely a real issue. And I was very disappointed that we didn't have more Republicans voting with us to affirm this fundamental right to travel between the states, but we will continue to fight for it in this Congress and into the future.
Representative, I'm going to press a little further on that last point that you just made about being disappointed in the inability of Republicans seeing the virtue in voting with you and other colleagues on this bill. In addition to being incredibly rigorous, you're also incredibly thoughtful. And I think that your district demands it. And folks who don't know, you are now representing a district that had for decades been represented by Republicans. And you were successful in your contest, especially because you had the ability to speak not just to Democrats and not just persuade independents, but also garner the support of average Republican voters in your district as well. Abortion and access to reproductive health is a contentious issue in this country. We know that the majority of Americans support your view and the view that we have at CAP, but it is a contentious issue. In your district, on the ground in Texas, as you try to build advocacy support to persuade Republicans in Congress to vote with you on this, what's the conversation that you're having with Republican citizens, voters, independent citizens and voters in your district, in your community, in your state? What are you hearing from folk who may not necessarily agree 100% on this? How are you making common cause there that could be a model for how we push this through in Congress?
Well, thanks, Patrick. That is, of course, a very thoughtful question. And it's interesting because as you noted earlier, and I mentioned, I've been involved in this work for a long time. And so in responding to this, I have a lot of confidence that my constituents believe in and support what I am advocating here and that I'm doing it on their behalf. And that is because these are consistently the views not only of my district, but of the majority of Texans. And there are a couple of sort of fun facts I'm happy to share with you. Number one, I grew up in this district. And when I was growing up, there were a lot of pro-choice Republicans. Every year, the Planned Parenthood luncheon, the big annual fundraiser, had lots of Republicans because this wasn't a partisan issue. It's very much in line with our values as Texans and believing in freedom and independence and the autonomy to make our own decisions, our own choices, and to have power over the direction of our lives. So this is a very Texas value that we're talking about when we talk about being able to make our decisions free from government interference. And importantly, This district has a long history of supporting access to reproductive health care. And the thing that so many people don't know, but I love to tell people, is that I do represent a district that had been Republican for 50 years until I won. I'm the first Democrat and the first woman ever to represent this district. But my predecessor, the first person to have this district when it moved to Houston, was George H.W. Bush. And he introduced in Congress the Title X Family Planning Funding Program. These are things that my community has valued, and I can tell you without hesitation that we care about family planning, people's access to healthcare and reproductive healthcare in particular, and that we believe across the board that these are decisions that are not to be made by the government. And that's why what you saw after the Dobbs decision, there was a survey, a poll that came out from the University of Texas at Austin, that only 15% of Texans agreed with a total ban on abortion that we see in our laws. 85% did not agree with that, and the vast majority supported abortion access in many cases. And so I think it is really important to listen. And I think it shows, as you mentioned, a little bit of our broken politics, that we have legislation in Austin that does not reflect the will of the vast majority of people. And that's something that we do have to talk about. And we have to engage with people to understand the importance of making our voices heard, of advancing smart legislation, and also seeing the connections. Because as you mentioned, this has been a sustained 50-state strategy with multiple prongs for 50 years to undo Roe v. Wade. And we've reached a point now, but we are not at the end. And I think it's just really important that people understand that we need a litigation strategy, which is, I know, the focus of so much of today, but we also need a legislative strategy. And we need to make sure that we are focused on how all of these things are interconnected, because the legislatures are where so many of the decisions are being made, and it's where the groundwork is being laid for further attacks on our freedoms.
Representative, can we clone you and just have you in every one of our districts across the country?
Well, I would love to be in your programs and to get to work with you more, because the work you do is so important and I'm so grateful for it. I'm really grateful for the opportunity to be with you today and to talk about these issues, because like I said, they're so important. And I think that what we see here is that these represent a fundamental threat to undoing so much progress in American society that we have made together in recent decades. And so, I would love to sort of add a couple of thoughts that might be part of the conversation as you continue. Of course, I mentioned, I think this legislative strategy is really important. And so I look forward to working with you on it and thinking about how we really support our rights to make our own decisions in Washington and in state capitals across the country. And I think it's really important to pay attention to these cases, the case we're discussing today, and an overall litigation strategy too, because what we see in Texas are the extremes. We see this case about mifepristone. We see a case brought by women who are showing the horrors of the implications of our laws in Texas and the life-threatening situations that they have been in, where they could not get access to care because the doctors are afraid to perform abortions, even in life-threatening situations, because of the not just the vagueness, but the really the cruelty behind these laws. And then we just had a case filed a week or two ago now under SB 8 that was seeking wrongful death suit against two friends who helped a woman get access to abortion pills. So we really see the gamut. We can't take our eyes away from what's happening in Texas. But like I said, we can't look only to the courts. We need a legislative strategy. And then we also need to look to the states where, we do have Democratic majorities. We see good progress, whether it's Illinois, Minnesota, Michigan. There's a lot of good work being done. And I think who is in charge of our legislative bodies really matters. So we have to pay attention there. And then my sort of last thought, and I hate to leave on a sort of, a ominous note, but I think it really is important and kind of a fitting segue here, because the ruling in this case will affect this too, which is this is not just about abortion. And you see it in this case. And mark my words, birth control is next.
Yep.
It's been FDA approved for a long time. When we put a bill on the House floor last summer protecting the right to access to contraception, including all FDA approved forms of birth control, only 9 Republicans voted for it. Only 9. So this isn't the end, it's just the beginning. And that's why I'm so glad that you're focusing on these matters, Patrick, and that you invited me to participate and share my thoughts today. I'm so grateful, and I'm just so glad to be with you.
The other side is clear about their intent, but we're clear about the superpowers that we have in legislation, litigation, and organizing. You represent all 3. We are so grateful for the time that you gave us and for your inspired yet grounded leadership. Thank you so very much, Representative, and thank you for taking us off of the back foot and giving us a rousing start to this conversation today. Thank you.
Thank you so much.
I'm going to now turn over. I'm pleased to turn the discussion over and to give the gavel to the director of our Women's Initiative, Sabrina Talukder. So Sabrina, over to you.
Hi, thank you so much, Patrick, and a special thanks to the audience for joining us for the panel discussion. My name is Sabrina Talukder, and I am the director of the Women's Initiative at the Center for American Progress, and I have the honor of moderating today's panel. I would like to introduce our esteemed panelists who are here in their individual capacities. Their comments today do not reflect upon their respective institutions or organizations. First, I'd love to introduce Professor Allison Whalen. She is the Assistant Professor of Law at the Center for Law, Health, and Society at Georgia State University. She has co-signed the Food and Drug Safety Scholar Amicus Brief in the Alliance case, which emphasizes the safety of mifepristone and the integrity of the FDA's internal decision-making process. Next, I'd love to introduce Professor Naomi Kahn. She is the co-director of the University of Virginia School of Law's Family Law Center, where she's a legal expert in constitutional law, feminist jurisprudence, and reproductive technology. She has published extensively on abortion issues for over a decade, and specifically on the current legal landscape of medication abortion. Last, we have Skye Perryman. Skye is the president and CEO of Democracy Forward. Democracy Forward is engaged in progressive litigation across the country and is currently counsel to Gen Biopro, the drug manufacturer of the generic version of mifepristone, and is counsel to Gen Biopro in the case Gen Biopro versus West Virginia. Additionally, Skye was the former general counsel for the American College of Obstetricians and Gynecologists, where she worked on legal and policy strategies that led to the distribution of mifepristone by mail in the pandemic. And without further ado, I'd love to ask Professor Whalen my first question, which is, we've heard from Representative Fletcher that this case is unprecedented in that a judge has never overruled the safety determinations of the FDA. Can you please explain why a judge's attempt to overrule the safety determination is so concerning to FDA scholars? And I'd love to highlight that in your publications, you've really emphasized the impact of health policies on systemically marginalized communities. So in your response, can you also please touch on how undermining the FDA's scope of power will aggravate these existing inequalities? Thank you.
Absolutely. And that in and of itself, that question in and of itself could fill much more than an hour. So I'll try to keep my remarks brief here. So as you and Professor Fletcher noted, and many others have noted, this case is unprecedented. Even the plaintiffs in this case admit that they're not aware of any other case in which a court has removed a drug from the market over the FDA's objection. So an adverse ruling for the FDA in this case, which at this point many of us are pretty much expecting, would undermine the long established statutory and regulatory framework for the approval of new drugs by the FDA. Professor Fletcher noted that the FDA approval process is often viewed as the gold standard for drug approvals throughout the world. It's what many other countries model their drug approval process on. As someone who used to represent pharmaceutical companies seeking FDA approval before I transitioned into academia, the time, effort, and the expertise of the pharmaceutical companies, as well as the FDA, that goes into the FDA regulatory and approval process is astounding. I know that the COVID-19 pandemic and other recent events have somewhat harmed the public perception of many health agencies, including the CDC and the FDA. And of course, no agency, including the FDA, is without criticism. But knowing what I know from behind the scenes in terms of what goes into the process and the time that the FDA gives this process, there's a lot of good reason to have faith in the process, that the drugs that are on the market have received a thorough review. Of course, not every risk can be known at the time of approval. We know that. But it works, this process works more than it doesn't. And of course, we know that no matter what the judge rules, how the judge rules in this case, it will be appealed. But should the judge hold that the FDA must withdraw the drug's approval or hold that the drug was approved incorrectly in the first instance, such a ruling would have reverberations and consequences across the entire healthcare system, regardless of whether that ruling is ultimately upheld on appeal or not. Our healthcare system, patients, providers, the pharmaceutical industry, and much more, we all rely on the FDA's expert scientific decisions about the safety and effectiveness of medical products that are on the market that we consume every day. Many of these medical products are essential to good health, if not our survival. And as Professor Fletcher noted, this case is about Representative Fletcher noted, this case is about so much more than abortion. And that is an extremely important point to remember. In fighting over abortion, we often lose sight of the collateral consequences. So should the judge go against the FDA in this case, as we are expecting, that opens the doors to challenges to other drugs and medical products that it has approved for other purposes and conditions. So no drug is without risk, particularly those that may be socially, ethically, or politically controversial for whatever reason. This would include contraception, hormone therapy, vaccines, gene therapies, and so much more. Innovations are happening every day that will bring more medications potentially to the market that could be controversial. And even while medication bans and abortions, to get to your last question, part of the question, they do impact the entire healthcare system. But we know it is easy to see the outsized impact that they have on historically marginalized and vulnerable populations, especially communities of color, low-income populations, persons with disabilities, and the LGBTQ+ population. Just before and after Dobbs, many viewed medication abortion and the ability to access it through the mail, potentially without needing to go to an office visit, as a potential workaround to some of these severe surgical abortion restrictions and bans that we saw. But the Texas case and other ongoing attacks on medication abortion at the state level, such as the recent legislation that was passed in Wyoming banning the drug, shows that medication abortion is not safe from attack, and it is not necessarily the post-Dobbs panacea that some hoped it would be. These politicized judicial rulings that might come out of this case and that are likely to come out of this case that restrict or eliminate access to essential reproductive health medicines that have been proven time and again by the FDA to be safe and effective, endanger the life and well-being of all Americans. Our healthcare system depends not only on the FDA's expertise, but also on national uniformity, stability, and predictability. Allowing judges to overturn these expert decisions threatens to upset the balance and endanger public health. And I just want to end my answer to this question by echoing Representative Fletcher's emphasis on the fact that overturning Roe was not the end of the battle. On the contrary, the battle may have just begun. Abortion was the beginning, and there are many more dominoes that can fall from here.
Thank you so much, Professor Whalen, for unpacking the question by being so thorough and with such clarity. I really appreciate it. I would now like to turn to Professor Khan. My second question for Professor Khan is, I would really love to sit on your class at UVA Law, particularly at a class called After Dobbs, and in addition to your courses on feminist jurisprudence. In the larger context of legal history and jurisprudence, what are the main takeaways you hope your students will remember about in this case?
Thank you for that question. and I hope you'll be a guest speaker in our class in the future. So in our After Dobbs course, we discussed 3 distinct issues that are relevant to the Texas case and to abortion access going forward. A first set of issues focuses on the irony that the Dobbs case turned over abortion access to the states. So in Dobbs, we have Justice Alito saying this is now a state decision, and that's where Dobbs left it. It turns out, of course, that the case that is at the focus of our panel is a federal court case with potentially national implications. So Dobbs has already resulted in a patchwork of state regulation, with red states moving to ban and indeed banning abortion and abortion pills, while blue states are seeking to protect access. We've read about state referenda, state attorney generals writing Walgreens, state Supreme Courts protecting or not abortion access, but this case is different. This case is seeking a remedy, as Professor Whalen just noted, against a federal agency that has national implications. So if the case forces the FDA to start withdrawal proceedings for mifepristone, that will have an impact in blue states, which will then have to rely on misoprostol as well as on surgical abortion. So rather than having to fight state by state on abortion access issues, this ruling could apply to all states. Those states with abortion access are already facing an overwhelming number of people seeking abortions, and this decision can make abortion harder to obtain even in those states. So it's using the courts to obtain a remedy that the anti-abortion opponents have not been able to achieve via the state political process. The second set of issues concerns, and we also talked about this in our course, what both Professor Whalen and Representative Fletcher referred to, which is the politicization of the drug approval process, the unprecedented nature of seeking a ruling that would reverse this 20-plus-year-old FDA approval for a drug that had repeatedly been demonstrated to be safe. And if this case is appealed to the Supreme Court, it will be appealed ultimately. Then it will go to a court that is, as Maggie Buchanan points out in the article in the chat, historically low approvals for the Supreme Court. So the final set of issues, and this is a whole cluster set of issues, relates to women and the impact of becoming pregnant, the issues relating to the rights of anybody who can become pregnant. So we can start on that with the erasure of pregnant people from Dobbs. The majority opinion devotes a mere paragraph to the impact of abortion restrictions. The dissent is quite expansive, however, on the actual impact. To read the majority opinion, one would think that such restrictions would pose little harm to anyone, given all of the alleged protections we now have for pregnancy and childbirth. But the court's depiction of the protections for pregnancy completely glosses over the difficulties with existing laws, the lack of protection for people who are pregnant and for people who have had children. So the court doesn't recognize the significant personal and bodily intrusion of forcing people to carry pregnancies to term. Childbirth is generally 14 times riskier than having an abortion. In Mississippi, where the 14-week ban was at issue in the decision, the risk was 75 times greater. And as Professor Whalen noted, abortion bans disproportionately impact women of color, young women, women with low incomes, and rural women. So a second aspect of this opinion is the importance of pregnant people taking control of their own bodies through self-managed abortions. People may prefer to self-manage their abortions for a variety of reasons, including not just because the nearest surgical abortion clinic is miles away, but there may be limits on health worker shortages, on few trained and willing abortion providers, as well as procedural and administrative requirements. And then the final aspect of this third issue relating to gender issues is the significance of women's ability to participate equally in today's world. There was a brief in the Dobbs case from economists arguing or pointing out that there's a strong relationship between women's ability to control their bodies and their ability to be employed and the freedom to make their own choices. So efforts that such as a Texas case that seek to limit access to abortion undercut not just the FDA's authority, our trust in the safety of our drug certification process, but also show the battlefront of abortion access occurring in contemporary culture and the impact on not just on people who are or can become pregnant, but the impact on the rest of us with respect to the politicization of this process. Thanks.
Thank you so much, Professor Khan, in grounding how overruling the FDA and so many things impacts every single one of us in the country. And now I have my third question for Skye. Skye, you have extensive litigation experience in expanding access to medication abortion. My question for you in this rapidly changing legal landscape of medication abortion is, what are some of the best legal strategies we have to protect access to medication abortion, both generally and specifically for the Alliance case, as it will likely go on appeal to the Fifth Circuit and potentially to the Supreme Court?
Thanks for that question, and thanks for having me on. I think maybe we'll start with access to medication abortion generally, setting aside the Texas case. And as Professor Khan and Whalen have noted, Dobbs sort of purported to return things to the states, but doing so in eliminating a federal privacy protection, not in eliminating any other federal protections, whether that is federal protections under the Emergency Medical and Treatment Act, federal protections around other elements of the Constitution, or federal protections in other sort of statutory and regulatory ways. And so in the post-Dobbs landscape, we've seen a number of states seek to ban or restrict abortion generally, or medication inclusive of medication abortion, some of medication abortion specifically. And those bans, while presenting a number of problems from a social and people well-being perspective, also present a number of problems from a legal perspective with respect to our Constitution, because our Constitution makes clear that federal law has to preempt or transcend state law when the two conflict. And what we have with mifepristone is a drug that has been regulated and approved by the FDA for 2 decades, that has been regulated and approved specific not only to a general overall drug regulatory structure, but to a very specific one that Congress put in place in amending the Food, Drug, and Cosmetics Act in later in its passage. And so, one area of legal challenge and legal strategy that you'll see moving forward. And of course, Gen BioPro, who I'm at Democracy Forward and others are representing, has started availing itself of this area of challenge, is challenge to state bans and or restrictions on medication abortion that violate the Constitution, because they're essentially placing state law as precedents over federal law or a federally approved medication. And here, particularly a medication that Congress and the FDA have both, in their judgment, have said is important to be available to people subject to a regulated structure. And so in West Virginia, Gen BioPro is challenging a ban on abortion and restrictions on mifepristone that go beyond the way FDA has regulated it, because it is FDA and FDA alone that gets to make these judgments in our country. And so I expect that you'll see other cases playing out. There's a case in North Carolina on restrictions with respect to mifepristone that a provider has filed. So I think that you'll see those playing out on the sort of more affirmative or proactive side. That, of course, puts in sharp relief why I think very extreme right-wing interests are dedicated to seeking to undermine the approval of mifepristone and undermine the FDA's authority more generally, because of these and other types of strategies that can provide pathways for access in a post-Dobbs era. And so, as we see in the Texas case, Many parties, including Professor Whalen and others, have filed briefs in that case in order to provide the court with more factual and legal background than what they would just get from their briefing. We will have to see how the district court rules. We do know, and this was discussed in the FDA scholars brief that was filed that Professor Whalen and others joined. We do know that there are a number of regulatory tools that the FDA and others have under our system of laws that our legal structure actually does not allow a judge to issue an order and take a product off the market. There are actual statutory and regulatory processes that need to be that need to be followed, and that sort of FDA is central to. And so I think those will be some areas to watch in the Texas case, including, of course, the Fifth Circuit appeals, which will almost certainly happen, and any sort of action that you see at the Supreme Court. The other thing I think to step out more broadly is there is nothing that a federal judge, that a appellate judge or panel, or that the Supreme Court, there is nothing that those courts can do that would undermine the facts of what the safety and efficacy profile is of mifepristone, which is a drug that has been approved for years. It has been well studied. There is documented evidence about its safety and efficacy. All major medical organizations, researchers overwhelmingly support the safety and efficacy of the drug and the use of the medication. And so I think it's important to also center that this is an incredibly concerning challenge that could have a lot of wide-ranging implications, and already is having those implications. That is not to say there are not other tools in the toolbox that can be used as we move forward, and it's also not to say that there aren't other regulatory pathways as we move forward, but that doesn't take away from the concerning nature of the drug. I also neglected to mention, I believe Professor Whalen has a article coming out on federal preemption. So for those that are interested in the way our Constitution continues to provide protections for people in the post-Dobbs era, would sort of watch that space and see what she has to say, as well as so many other scholars that have been writing on this, and of course following litigation in places like West Virginia, where we're actively working to protect pathways of access for people in states against state overreach, against the state's attempt to deprive people of what is essentially a federal benefit, and is something that everyone in this country is entitled to, which is the expertise of the FDA, our overall regulatory structure, and the availability of this medication.
Sky, thank you so much for providing such a thorough response, and for reminding all of us of the limitations of the judicial system, and that judges don't get to do anything that they want all the time, that there is a system in place to protect us. And I'm very grateful to end my questions on that note, and I would love to open this up to audience members. And we have a great question that makes me feel like I'm back in law school, so professors especially, I'm going to keep you on your toes. The question is, if the Texas district judge orders the FDA to withdraw mifepristone's approval, and the FDA complies with that order, can the FDA's withdrawal decision be appealed to the DC Circuit per the statutory withdrawal provision, or will any appeal have to be limited to the Fifth Circuit? And I open that to any of our wonderful panelists who would like to take it.
Just who wants to speak to that? I mean, I'm happy to talk a bit, but
go for it, Sky.
Okay.
Go for it.
So the appeal in the case that is before Judge Kaczmarek, that's a case, it's a federal district court in Texas that appeals to the Fifth Circuit and to the Supreme Court. There is, however, and I think our scholars could also enlighten us, there are, however, in the statute, there is at least approval holders, which would be sort of manufacturers of medications, have the ability to challenge in the DC Circuit or in another circuit where they're located any sort of decision by the agency to withdraw to withdraw approvals, and there's some other statutory text around that, which maybe Professor Whalen or others could talk through, because I know some of that is in the brief that was filed. But in terms of the exact case in Amarillo, I think in general you're going to expect to see that up through the Fifth Circuit and then potentially at the Supreme Court. That said, there could be other stakeholders that may have the ability to challenge certain actions that could occur as a result of any order in that case in other courts.
Yeah, I would agree with that. It kind of like depends on what exactly they're appealing. For example, if they're appealing the judge's direct order, I would agree that's going to be within the Fifth Circuit. But say the judge, again, it depends on kind of the language of the order that ends up coming out. If the judge says the FDA has to withdraw the approval of mifepristone, I think the FDA might interpret that ruling as saying, okay, we have to therefore start the withdrawal process that is listed out in detail in the regulations, which doesn't mean that the drug would necessarily come right off the market immediately. The FDA would then start this lengthy process, which then requires the FDA to offer the opportunity for internal hearings, internal agency hearings. And then, that has a number of different layers and processes that the FDA has to take. So that's one way that FDA could interpret that sort of order and say, all we have to do based on this order is just start the process of withdrawal to see if we even are going to withdraw it. Again, whether or not that's what the judge intends, I think the judge intends to try to get it off the market immediately, most likely, but the FDA could certainly interpret it that way. And then that would work its way up and be appealed to like DC Circuit, et cetera.
Just to add that this is obviously whatever the judge decides, that's not going to be the last word, both because either side might appeal depending on what the outcome is. And then there are other cases around the country dealing with this. And then there's, of course, the FDA statutorily required administrative process. It's also important to remember that abortion access providers are looking at the possibility of continuing medication abortion just with misoprostol rather than with the drug at the center of this case. And so this doesn't, whatever he rules, if he rules against the FDA's approval process, this does not mean the end of medication abortion.
I would just comment that I think, part of the reason that everyone, legal scholars, I mean, I'm not aware of one that hasn't said it, that it's sort of so clear about how unprecedented and baseless this case is. I mean, it's really unfortunate that we're in a situation where we're even having to have these discussions, is that there is a statutory and regulatory process that the agency is required to follow. And of course, in our country, it isn't judges that sort of have the role of taking products off the market. And there are these very considered processes that Congress and the FDA have put in effect. And so I definitely think, as I mentioned, like that is a place to watch as things go up, and then in the sort of direct appeal process as well, you could see some movement there.
Thank you both. Thank you all so much for these incredible responses. We have one more that I'd love to share. Do you see the decision potentially impacting access to IVF and other assisted reproductive health services? And Professor Khan, given your expertise in reproductive technology, I'd love for you to start us off. Thank you.
It's important. This case is only about the FDA approval process for one drug that is part of the 2-drug regimen for a medication abortion. So this particular case should have nothing to do with in vitro fertilization, with other forms of assisted reproductive technology. Nationally, there's been a great deal of discussion on what to do, for example, with the excess embryos that result from in vitro fertilization, how to treat those embryos, how to think about issues of fetal personhood when it comes to those embryos. So there's certainly a lot of national discussion on that. On the other hand, you have people like former Vice President Mike Pence, who is a staunch who's staunchly anti-abortion, nonetheless saying that he and his wife his wife has undergone in vitro fertilization. So I think there's certainly a separation of the two issues by many people. Now, that doesn't mean, of course, that in states that ban abortion, that there may not be implications for in vitro fertilization. And when Dobbs came down, I had many people asking me what they should do with embryos that were stored in states that were likely to ban abortion. So there's certainly a great deal of concern about that.
Thank you so much, Professor Khan, for really emphasizing what this case is about. And again, that the power of the judiciary is limited. This case is really about the FDA approval process and the specific drug in question. Professor Whalen and Skye, do you have anything to add? If not, I'll happily move on to the next question.
My only comment, I think, is just more generally stepping outside of this case. I think the remarks that Representative Fletcher made and others made are sort of really on point around just the overall, this is a movement that initially insisted that they weren't opposed to all abortion, only some abortion. It was a movement that initially insisted they were good with contraception or IVF. And now you're seeing sort of this very extreme movement sort of try to move the baseline. That's not to say that's not an issue in this particular case, and we need to take each case on its sort of facts and sort of with the limitations of what it is. But I do think we're seeing a concerning trend of this movement continuing to move the baseline and really seek to undermine evidence-based healthcare. Today's the anniversary of the ACA, but evidence-based healthcare across a range of not only reproductive healthcare issues, but of course we've seen in other public health issues as well with vaccines and other things. So I do think there's an overall broader trend, which is why I'm so grateful for you all for having this discussion today about the overall politicization, but agreed that this is a very, this case is quite limited with respect to its impact there.
Yeah, I agree. This is just kind of representative of the broader theme and the broader fight. And I mentioned it, Representative Fletcher mentioned it, that, this is Roe v. Wade was not the end, and this is just kind of one component. Obviously, fetal personhood is another step. And if if fetuses are deemed persons under the law, that has huge implications for IVF, as well as many other areas, including research on pregnant persons, because if a fetus is deemed a person, then you would have to be able to have consent for the fetus to be involved in research. And clinical research is already so difficult on pregnant women. And so fetal personhood laws would make that even more difficult.
Yeah, just to emphasize, this is one case. This is, I think, what we're all saying, but it is, again, what we're all saying, this is part of an overall strategy. And this one case, although this one federal court case could have national implications, and it's an example of how the movement is fighting not just state by state, but also on a national level to restrict abortion access. And then there were concerns when the Dobbs opinion came down about just how broadly Dobbs could be taken with respect to other rights that we all take for granted.
Thank you all so much. I think a resounding theme has been that there are limitations of what these judges can do, and also how much this impacts systemically marginalized communities, as well as the legal pathways moving forward. And right now, this is the end of our panel. And I would really like to thank Professor Whalen, Professor Khan, and Skye Perryman for sharing their expertise with us today. And to our audience, thank you so much for joining us, for the excellent questions, and for standing in solidarity with us on these intersectional issues. And I would like to especially thank the Women's Initiative, Events, and Government Affairs team at the Center for American Progress for their efforts in putting this event on. And once a decision is released, CAP will be releasing written and video explanations, decoding the order, as well as a series of reports on the decision, focusing on the path forward to appeals. And again, I can't thank our panelists enough, for Representative Fletcher for joining us, And of course, I'd like to really thank the audience for attending. You could have spent this hour in many ways, and we are so grateful that you've come with us as we all collectively try to move forward in a manner that protects Americans for their access to healthcare and abortion care specifically. So thank you again for attending, and I hope you can enjoy this beautiful afternoon. Thank you so much and have a great day.
Thank you.